Hi, this is Bob Pickle from Pickle Publishing. We have a number of stories for you today. We'll even talk about how 3 bank accounts got hijacked. But we'll begin with an update of our July 12th investigative report. In that report, we explained how the public was misled regarding the $834,197 theft in August last year from the Minnesota Association of Townships Insurance Trust, called MATIT for short. If you haven't seen that report yet, consider watching it first by clicking the link in the description below. This update concerns follow-up questions we asked the Minnesota Association of Townships, called MAT for short, and MATIT on July 19, and the unusually quick response we received from one of MAT's external attorneys. MATIT Operations Manager Heather Tidmore stated in the spring 2022 issue of Minnesota Township Insider that she had relocated from the Houston, Texas area. But according to the sheriff's report about the theft, Kingwood, Texas was still her address on August 24, 2022. Tidmore also stated on her publicly available LinkedIn page that she started working for MATIT in February 2022 and was still working for her previous employer, Houston Methodist, the following November. Thus, between February and November of 2022, she was working for both MATIT and Houston Methodist. We released our investigative report in the morning of Wednesday, July 12th. Sometime between July 5th and 2:40 p.m. on July 12th, Tidmore's LinkedIn page went missing. That led us to ask MATIT some follow-up questions on July 19. The spring 2022 Insider issue contained the February MAT board minutes. These minutes authorized the hiring of Robin Sykes as a mentor for Tidmore for 4 months, but Sykes' employment lasted far longer than 4 months. All these facts led us to ask these questions. Was Sykes hired to mentor Tidmore, or was he hired because Tidmore was still working for Houston Methodist and thus wasn't around? Was Tidmore being paid full salary by both MAT and Houston Methodist? Were the MAT and MATIT boards ever told that Tidmore was still working for Houston Methodist and still living in Kingwood, Texas? These are fair questions that the public should have a right to know the answers to. MAT and MATIT control millions of dollars of public funds, and nearly $1 million of it went missing last August. Here's the response we got to our questions, sent the same day, July 19, at 5:23 p.m. This letter demanded that we cease and desist from looking at online information about Tidmore or else, and yet Tidmore's LinkedIn page was public. Our questions on July 19 fell into 7 categories, and the questions concerning Tidmore were only one of those 7. Another category concerned Kruger's uncomfortable interactions with the Farmington City Council in 2003, including occasions involving law enforcement. Yet another concerned Kruger's apparent violations of his contract with MAT. But no demands or threats were made in this letter regarding any questions other than the ones about Tidmore. Something must be very uncomfortable about Heather still working at Houston Methodist until last November. The Data Practices Act says in Section 13.43 that certain personnel data, such as salary and expense reimbursement data, is public data. So is work location data. I had every right to ask for this information on April 17. The Data Practices Act requires that responses to data requests be appropriate and prompt. The July 19 cease and desist letter is the only response I have ever gotten, after having waited 3 months and 2 days. It was neither appropriate nor prompt. In our last report, we looked at part of Kruger's spring 2023 article in the Insider. Kruger leads the reader to believe that he values truth and transparency. But then, why did MATIT's February 7 letter about the theft contain so many discrepancies, as shown in our previous report? And why did the attorney send that cease and desist letter instead of answering at least one of the various questions we asked? Kruger also uses the word retaliatory and asserts that the MAT board minority is retaliating against him. Yet he's the one who filed a retaliatory lawsuit against Mike Miller. The board minority hasn't sued Kruger. The board minority being retaliatory and opposed to truth and transparency instead of Kruger? Seems like a tough sell to me. It seems as if Kruger's assertions are unreliable. We now move to our next segment. MAT defies state law, refuses to comply with the Data Practices Act. What happens if a government entity farms out some of its functions to a private person? Section 13.05 of the Data Practices Act deals with this. Subdivision 11 says that for those functions, the private person must comply with the Data Practices Act as if it were a government entity. Thus, government entities such as MATIT can't evade the Data Practices Act by farming out all their functions to private persons such as MAT claims to be. Subdivision 11 also requires the contract between MATIT and MAT to contain a clause that puts MAT on notice that it must comply with the Data Practices Act. I've read through that entire contract, and I couldn't find any such clause. Back to the attorney's July 19 letter. She in essence states that MAT refuses to comply with my data request. Thus, MAT defies state law. MAT, the entity that teaches townships how to comply with state and federal law, refuses itself to comply with state law, a state law intended to promote transparency and accountability in government. But the attorney also informs me here that MAT refuses to provide me with copies of its financial statements as it told the IRS in Schedule O of the Form 990 that it would do. That leads into our next segment. Will the IRS come knocking? Here's where MAT's most recent Schedule O says that the last 3 financial statements are available upon request. I first requested MAT's last 3 audited financial statements on May 19, along with the most recent Form 990 filing. The IRS requires a nonprofit to respond to written requests within 30 days and in-person requests immediately. I received the requested 990 on June 9th, but have never received the promised financial statements, even though I brought this failure to the attorney's attention on June 12th and 23rd and on July 17th. If anyone stops by the MAT office and obtains the audited financial statements, I would be most appreciative if you could forward a copy to me. Now let's talk about MAT paying for Kruger and Burdorf's personal private lawsuit against resigned MAT Director Mike Miller. Here's a page from the IRS's website. This paragraph explains that an excess benefit transaction is where a disqualified person gets something from an organization such as MAT without that person paying fair market value for it. Thus, if Kruger and Burdorf pay a fair price to MAT for MAT paying for their private legal expenses, everything is fine. The IRS defines disqualified person as someone who can exercise substantial influence over MAT's affairs. Kruger and Burdorf certainly fit this description. What's the penalty? An excise tax equal to 25% of the excess benefit. If the problem doesn't get corrected within a certain time period, a second excise tax of 200% gets imposed. And here is where it says that the person, not the organization, is liable for the 25% or 225% excise tax. Suppose MAT ends up paying $50,000 to $100,000 toward Kruger and Burdorf's private legal expenses. If the IRS determines that this qualifies as an excess benefit transaction, Kruger and Burdorf might have to pay $12,500 to $212,500 in excise taxes to the IRS, out of their own pockets. But there's more. Each MAT board member who voted last August to have MAT pay for Kruger and Burdorf's personal private lawsuit under certain circumstances could be required to pay an excise tax of 10%. Good news for the MAT board majority is that they can't be liable for more than $20,000 for any single transaction. If the IRS determines that the excess benefit of MAT paying for the lawsuit amounts to $50,000 to $100,000, 10% would then be $5,000 to $10,000 apiece. And here it says that depending on the circumstances, an individual might have to pay both excise taxes. Burdorf is both chairman of the board and the beneficiary of MAT paying for his private lawsuit. Hopefully the special circumstances that could result in his having to pay both taxes wouldn't apply to him. We now turn to the next segment of today's report. MAT conspires to hijack county unit. Here's the timeline about key events regarding the Norman County Association of Townships, called NCAT for short. The issues actually started in 2020, when it took an entire year to get our bank accounts updated because of a lack of help from MAT. But we'll start this timeline with the morning of October 13, when I stopped by the MAT office to inspect the Form 990s as permitted by federal law. That afternoon, the MAT board voted to no longer recognize NCAT and to kick out 5 Norman County townships. On January 5, the MAT board voted to expel the 5 townships on January 10. On January 17, Kruger offered to assist anyone who wanted to get rid of NCAT's directors. Here's Kruger and Burdorf's January 17 letter. Here's where Kruger offered to assist anyone who wanted to oust the existing NCAT directors. The result? NCAT's annual meeting on March 10 got hijacked. One of 3 chief conspirators asserted that NCAT's bylaws are a legal document and must be followed, and that since the bylaws require the payment of MAT dues to be NCAT members, the existing directors couldn't be directors because their townships weren't members. Another of the 3 chief conspirators said that the 4 affected townships couldn't vote, and thus those townships weren't allowed to participate in the elections that day. Therefore, the alleged elections that day, which resulted in 3 alleged replacements, involved voter suppression. But in reality, what was done violated NCAT's bylaws. The dues deadline hadn't arrived yet, and thus the 4 affected townships were still paid up. I've got an email from MAT's Jesse Peterson, which says that June 1st is the absolute deadline for paying dues. MAT's membership cards state right on them that they expire on June 1st. Historically, NCAT townships never pay their dues until after NCAT's annual meeting in March. Nobody asked about what other townships hadn't paid their dues yet. The 4 affected townships weren't the only ones. The conspirators never disclosed that day that NCAT's bylaws require that MAT dues be paid to NCAT. No Norman County township is doing that this year, and that was MAT's choice, not NCAT's. The conspirator that said at the annual meeting that the 4 townships couldn't vote, I was told that he later denied saying any such thing, and then he personally denied it to me too. NCAT's bylaws are clear. Only members can vote. If the officers of the 4 affected townships can vote, then their officers can be directors too. Then on March 17, another chief conspirator said that her township was pulling out of NCAT. Here's where she told me that. The alleged elections at NCAT's annual meeting resulted in only 3 seats of 5 being allegedly filled, and out of those 3, 2 of them were 2 of the 3 chief conspirators, and those 2 were from the same township. And here this notice says that that very township was pulling out of NCAT. They couldn't serve as directors if they had pulled out of NCAT. Problem solved? In the more than 4 months since this email, I have never received another notice from this town officer telling me that her township had changed its mind. This whole mess could end up in court, and the original NCAT board wanted to meet with the alternative board to find a way to protect our local people from liability. But Kruger didn't want that to happen. Though a meeting was scheduled between the 2 boards, the original board was never notified, because the other side was told at the Minn short course not to meet. And that leads us to the next segment of today's report. NCAT's bank accounts get hijacked. The NCAT board had decided a while before to use its CD rather than raise the dues a bunch to cover all the extra costs that MAT had caused NCAT to incur. And so on April 14, I called the bank to inquire about closing the CD. 4 days later, unspecified people had the bank replace the existing signers without notice on all 3 accounts. I found out the next day. The accounts were frozen. That night, Kruger emailed me at 11:09 p.m., CCing 4 of the 5 alternative board members. 2 of those 4 weren't even NCAT members anymore, since their township had pulled out of NCAT. How could they hijack bank accounts of an organization they weren't even members of? Multiple bankers have told me that a safeguard against accounts getting hijacked is involving the existing signers in the changes. But in this case, that didn't happen. After the bank couldn't tell me that I would be notified once the dispute was resolved, I went home and filed a complaint with the OCC, which the OCC told me on the phone to do. But the OCC later told me I couldn't file a complaint unless I was an existing signer. Thus, if your bank account gets hijacked, the OCC won't help you. I then filed a complaint with the Consumer Finance Protection Bureau, and that led to my receiving for the very first time written confirmation from the bank that I had a dispute, and a statement that the accounts would remain frozen until the two sides agree or there is a court order. Here's a letter the bank sent the alternative board. Using a pickle green color, I've redacted all the identifying information as a courtesy to the bank and to whom the letter was sent to. Here's where the letter says that the accounts will remain frozen until there's a court order or the two sides agree. Townships rely on MAT for legal information to hopefully help protect the townships from getting mired in some sort of legal quagmire. Given how big a quagmire MAT has created under its current leadership, townships would do well to be cautious in that regard. But the quagmire gets bigger yet. Our next segment is how Gary Burdorf told the IRS that MAT has no authority over county units. Here's MAT's most recent 990, the 2021 form. It says that MAT's fiscal year ended on June 30, 2022, and Gary Burdorf signed it on April 12, 2023, under penalties of perjury. Part 6, Section B, Line 10A, asks the question, did the organization have local chapters, branches, or affiliates? The answer given is no. Does that strike you as odd? Aren't county units affiliated somehow with MAT? If county units are units of something, what are they units of? When MAT first incorporated in 1934, one of its names was the Minnesota Unit of the National Association of Township Officers. MAT was a unit of the National Association, whatever that was, and thus the county units must be units of MAT. So how is Burdorf able to say that MAT has no affiliates? Let's look at the IRS instructions for the 2021 Form 990. We'll read the instructions for line 10A. Answer yes if the organization had during its tax year any local chapters, local branches, local lodges, or other similar local units or affiliates over which the organization had the legal authority to exercise direct or indirect supervision and control. There you have it. Burdorf signed the form under penalties of perjury, declaring that MAT has no local units over which MAT has authority to exercise direct or indirect supervision and control. And thus we asked MAT these questions on July 19. It looks like an impossible situation for Burdorf. If he was correct in his answer in the Form 990, then MAT must have been wrong in voting on October 13 to no longer recognize NCAT and seeking to control NCAT since. But if the MAT board did have such authority, then Burdorf endorsed a false statement in the Form 990 under penalty of perjury when he in effect said that MAT has no legal authority over county units. Which is the correct answer? The attorney made pretty clear in her July 19 letter that MAT isn't going to answer these questions at all. We now take a walk down memory lane and discover that in days gone by, MAT was more involved in the existence of the county units, and yet simultaneously, MAT membership by these county units was voluntary. Those truly must have been the good old days. Here's the July 27, 1961 issue of the Ivanhoe Times. Here's where that issue says that Henry Brummer was elected at MAT's annual meeting to go and organize the county unit in Lincoln County. When I told Steve Fensky about this fine, he responded that that doesn't prove that MAT created all the county units formed. That's indeed true, but if Fensky was really working for us here at the grassroots, why bring up as objections the various arguments an opposing attorney might raise? Here's a letter Joe Kappas sent out after NCAT was formed on October 15, 1971. The first paragraph says that MAT's Vice President, Irvin Strandquist, and MAT's Executive Secretary, Dan Holtz, were present. Today, we would have called Holtz the Executive Director. The same letter says that NCAT was formed as a unit of MAT. And there you have it. That's why county units are called units. They're units of MAT. This letter refers to the Minnesota Association of Township Officers, or MATO for short. I have quite a few documents to prove that MATO and MAT are the same organization. MATO officially changed its name to MAT in 1979, though both names were used before and after that year. For 13 years, MAT's 990s have said that MAT formed in 1933. I used this fact at the District 12 meeting last year as part of my argument that since MAT created the county units, it has a moral obligation to help them. but Fensky, for some reason, seemed to prefer saying that MAT formed in 1979. Here's the most recent Form 990, signed by Burdorf last April. Lo and behold, it now says that MAT formed in 1979. Why would Burdorf now declare under penalties of perjury that MAT formed in 1979? I don't know. On November 23, 2022, I personally sent him a page from MAT's newspaper, the May-June 1983 issue, which announced that MAT was celebrating its 50th anniversary that year. Here's a page from the January-February 1987 issue of MAT's newspaper. 3 longtime board members were being honored. They were honored at the 1987 annual meeting, 8 years after MATO changed its name to MAT in 1979. Strandquist, the fellow who temporarily chaired the meeting in 1971 that organized NCAT, served the longest on the MAT board, 23 years, beginning in April 1965. This is just one of many articles which proves that MAT existed long before 1979. The article also credits Strandquist with starting many of the county units in the northern part of the state. Here are NCAT's original bylaws. Notice how there's blanks to be filled in. What does that show? It shows that MAT provided town officers with a suggested set of bylaws with blanks that could be filled in. Lastly, note what Section 1 of these bylaws say. The county association may become a member of MAT. May means that membership was voluntary. Townships could choose to become members of NCAT, but didn't have to be. County units could choose to be members of MAT, but didn't have to be. Let's summarize. Once upon a time, long, long ago, MAT assisted in the formation of the county units. When forming those county units, MAT provided sample bylaws that permitted the county units to decide for themselves whether they wanted to be part of MAT or not. They weren't forced to be. That's enough information for today. As we wind down our report, many may ask, what can be done? You can share the links, subscribe, and click like for this report and our last one. The more likes and subscribes there are, the more the impression will be given that the public considers the issues we are covering to be very important. Share with who? And not just town officers. Share with state legislators too. One problem in this whole saga has been finding an agency that thinks it has jurisdiction. Normally, the Commerce Department oversees insurance, but Minnesota Statute Section 471.982, Subdivision 3, exempts MATIT from a good bit of that oversight. Someone needs to have oversight when $834,197 gets stolen and the public is misled about it all. Maybe it's time to repeal MATIT's exemption from oversight. Go to your district meeting. Ask questions, insist on sound answers, express concerns, and why not see if a no-confidence motion passes? If it disturbs you to see MAT deteriorate, then make sure you have a district director that will deal with the issues before it's too late. We close today with this final segment. Other insurance is available. For quite some time, MAT has just about had a monopoly offering township insurance in Minnesota. MATIT's insurance is indeed inexpensive, though it was voted last September 14 to raise the rates. Out of necessity, due to MAT expelling the 5 Norman County townships and MATIT canceling their insurance, an alternative had to be found, and it wasn't easy. Clerk and treasurer bonding isn't difficult to find. One's local bank or insurance agent can often help with that. General liability and public officials coverage can be more challenging to find. A public officials policy would be what provides you with errors and omissions or E&O coverage. This company, Selective, can provide general liability, public officials, clerk and treasurer bonding, workers' comp, and property insurance for townships, and the cost was pretty good. Selective's domain name is selective.com. This is a web page at northriskpartners.com. North Risk Partners is an insurance agency that sells Selective policies. Here's a map of where all their offices are in Minnesota. And here are the cities where those offices are located. So if you're interested in seeing what Selective can do for you, you could call North Risk Partners and inquire. There may be other options as well, but this is what my research turned up. And that ends our report for today. Thanks for listening.